Hi, everybody. It is Kimberly Banks Fawcett, and this is the DFW Note Closers Group. It is our June 2019 webinar. I can't believe it's June already. Time just flies. Every year, I think it gets faster. But tonight, we have the wonderful and talented Erin Quinn. She is going to talk to us about foreclosures in Georgia and Florida. That'll be a great comparison, even though they're right next to each other. Georgia is judicial, Georgia is non-judicial, Florida is judicial. So you compare, contrast, do all of that. And then when she's done with that, she's going to talk a little bit about the due diligence that she needs to see in a file so that things can move smoothly. So with that, take it away, my dear. Let's see.
Okay.
I will. Oh, no, we don't want to do that. All right. So I'm going to, you need to hit the green button at the bottom, and that will let you share your screen.
Perfect.
There you go.
You see it, guys?
Yep.
All right, cool. All right, let me do this. Let me know if you can see it when I enter full screen view. You good?
Yep.
Okay, cool. All right. So let me go back this way. Out of here. All right. So I did this. I've done this due diligence overview plus foreclosure and Georgia, or excuse me, Florida and foreclosure and bankruptcy, and Georgia and foreclosure and bankruptcy for a local meetup group here. So what I'm going to try to do is go through these processes, and to the extent that you guys need to interrupt to ask questions, feel free to do that. I don't want to get too far into things without you guys, you know, having your questions answered, because sometimes they build on the concept. So my point of tonight is essentially to show you through a judicial foreclosure versus a non-judicial foreclosure and why they are done differently that way. And at the same time, I'm not going to get too into the weeds on the legal aspects of things unless you guys have questions, just because a lot of that will be left to the attorney that you engage to handle your processes. So we'll start with that. And then at the end, I was just going to go through, or probably middle of the way, we'll go through due diligence and spend some time in that based on what I personally have reviewed and seen in some of the due diligence I've helped on with some smaller note investors since I opened the firm officially a year ago. So for what it's worth, I've been in the industry for about 17 years, first as a legal assistant and then as an attorney. And I've been an attorney since 2009, got my Georgia license in 2016, but I had done the work as a legal assistant, and being that it's non-judicial for the most part, it's, you know, fairly simple for me to make that conversion. So that's kind of a little bit of background for me. My assistant is also here. She's been with me for close to 10 years now, and has also been in the business 17 years, as has my partner. So we're located in Clearwater, and we run both foreclosure and bankruptcy in Florida and Georgia out of this office. And so if you have any questions for me, you know, you can feel free to reach out, and Kim can provide my contact information to the extent that she wants to. And I think I included it on the slideshow as well. So we'll just get started on it so we can move forward. Oh, I did have it in here. I have the BQPA intro. So here's the basic gist of it. I will send this out to you guys, or Kim, I'll send it out to you, and you can distribute it if you want, or, you know, provide it to the meetup group.
Yep.
Robert Bowen is actually my mentor. When we started at the same firm, him as an attorney and me as a legal assistant, about 17 years ago. And through the years, we finally came around to circling in and being partners. So, you know, we have our small office here located in Clearwater. Our email addresses are at the bottom. So foreclosure overview. A lot of people I know shy away from judicial states because of the time required in completing them. So I just kind of want to run you guys through why there are these differences between states. So in Florida, Florida's a title theory state, or I'm sorry, a lien theory state. Georgia's a title theory state. So what a lien theory state is the mortgage on the property or contract for deed, or however you want to name it, because Florida treats them all the same way, acts as a lien rather than actual title to the property. So the reason that you hear things like, oh, O.J. Simpson, purchased a property in Florida to protect his assets is because property ownership in Florida is actually protected by the Constitution. And there are only a couple ways that your homestead property can be stripped in the state of Florida from you. Non-homestead property is subject to judgments, and they're always subject to foreclosure. But homesteaded property will always be exempt from judgment holders or judgment creditors, and essentially it requires that you subordinate your ownership rights when you sign a mortgage. So you have 3 documents. You have the actual deed, which is going to be title from seller to buyer. And then you have the promissory note, which is your debt or your actual monetary promise to pay a certain amount of money between the lender and the buyer. And then the mortgage is actually the tether of that note to the ownership of the property of the deed, or to the property specifically. So it being that's kind of how the lien theory is. And in comparison to that, to kind of give you the contrast, in Georgia, as a title theory state, the mortgage doesn't just create a lien that can be sued upon and ownership of the property can be taken. It actually gives you a power of attorney, and you essentially take legal title to the property. So although you have a quote warranty deed or a quitclaim deed by which the buyer takes title from the seller, they then convey that title interest or that legal title interest to the mortgage company through the security deed. So that's kind of how I try to remember it. And usually how I guess I always remember it. I don't try to remember it, but that's how you'll get, you can tell the difference usually between lien theory versus title theory. In Georgia, a mortgage actually operates as the same way as it does in Florida. So a mortgage in Georgia is also a lien, but Georgia distinguishes between mortgages and security deeds in the sense that that security deed will actually give that legal title and that power of sale and power of attorney to the lender, versus the mortgage will create that lien and is required to be foreclosed judicially. So that's where you see in this slide the judicial versus non-judicial, depending on the language in the loan documents. So you'll have a warranty deed between buyer and seller in Georgia. Your note is, again, your promise to pay. Your security deed is, again, a tether to the property, but it allows that lender to essentially keep a power of attorney for the borrower and allows them to force sale without having to proceed through the judicial process. So that's kind of the difference. You're always looking in the loan documents for the grantor and grantee, that the legal title is vested in the grantee of the deed, which would be the lender. The grantor, retains beneficial and, use of the property. You'll see in the Georgia, one of the bigger things in Georgia or in most non-judicial states that contain that quote power of sale language is you always want to make sure that language is in the document. In the absence of an express power of sale in the loan documents, one of 2 things can happen. Either A, if they're based on, the uniform covenants of the Fannie Mae and Freddie Mac loan documents, then you can sometimes reform that document to include that language and proceed with a non-judicial action. Or, if you're not able to do that, you would have to foreclose it judicially. When that happens, the outcomes between Florida and Georgia are very different. So although in a mortgage or a lien process, it's the same as far as it goes through the court system and civil procedure. In Florida, when a second mortgage, for instance, sells a property at auction through a judicial sale, it sells subject to the first mortgage. And they take the proceeds from the sale, like their full payoff. So say, somebody comes in and bids at the second you know, $50,000 and wins it when only $30,000 is owed, there's going to be $20,000 in surplus left in the registry. The $30,000 will be paid to the second mortgage. That $20,000 will remain in the registry for junior lien holders, and then that title transfers subject to the first mortgage. So the first mortgage can come back in there and foreclose out the the junior lien holders and take the property away from the third party that purchased at the foreclosure sale. In Georgia, if it's a mortgage versus, so we're talking like judicial process, not the security deed. Once a second mortgage obtains a judgment and forces that sale, the proceeds actually go in the registry and they are dispersed according to priority. So it doesn't happen subject to the first mortgage. The first mortgage is actually required to be named and notified, and they are entitled to proceeds before the second touches them. So in theory, you know, unless you have equity in a property in Georgia on a judicial side, you would not want to proceed with a foreclosure, because the second you do, if it's underwater and, you know, there's 165 owed and the property sells for 150, that first mortgage is getting everything, and you just spend all your time and energy proceeding with a foreclosure action, and you're not going to get paid. So in Georgia, it's very important to make sure that any, you know, property that you're wanting to proceed upon is going to be like have that power of sale language, which allows you to proceed with a non-judicial foreclosure and allows you to take the proceeds subject to the first mortgage. And if it's a mortgage in that state and does not contain that power of a sale language, you'd want to ensure that there was enough equity in that property where you get a return on your investment if you do purchase it. So to kind of go into some of these well, actually, let me first ask, is there anybody that has any questions so far on the two concepts? Like, are there any points of clarification?
Well, I have a question. If you explain again what I would need to look for if I was trying to buy the second and wanted to eventually foreclose from second position. What do I have to look at?
Or Georgia?
Say that again?
In Florida or Georgia?
Oh, Georgia.
Okay, so in Georgia, what you want to make sure is that if you're wanting to purchase and you're wanting it to be non-judicial, it's going to be in the form of a security deed that provides essentially a power of sale or power of attorney to the lender that allows that non-judicial foreclosure to take place. It's usually your acceleration paragraph where it says, you know, you have to provide a demand letter and this is how you can foreclose, and it'll list that language in there, and it'll actually say if a power of sale is granted, then you can sell it by non-judicial action, and it'll name how you know, based on the statutes in that state or whatnot. If you are looking at a document that does not have that power of sale language, and you're looking at a second mortgage, you want to ensure that you account for the value or the payoff of the first mortgage and get that appraisal and figure out if you have enough, you know, if you bid on that second mortgage to also pay off the first. Because if you force a judicial sale of the property through the mortgage, not the security deed, then you're going to essentially be paid out in priority. And that basically means all the proceeds go in the registry, and then you, the first mortgage is paid first, and then you would get payment following that. And then obviously if there's applicable HOAs, depending on the priority of those other encumbrances in your title search, you need to make sure that essentially everything before you is covered. Does that answer the question?
It does, but I'm just curious. So if I'm buying a second, I make sure my second has the security deed in the right language. In that scenario, do I need to care if the first also has that language? Or is that irrelevant to me?
It is relevant to you because the first can foreclose you. So just as in any state where you would buy a second mortgage subject to the first mortgage, or a second security deed subject to the first security deed, it's the same scenario, essentially. So you want to, depending on your exit strategy from the second mortgage purchase, where, you know, for instance, in a non-judicial state like Georgia, you get in, you quickly foreclose, you get it out, you get it in REO, and you, again, have to sell subject to the first mortgage. So you either sell your interest subject to the first mortgage, take your, you know, money from the sale, you know, hoping to get out from, you know, a third party, or you have to pay off that first mortgage. So, and they also have the right to proceed non-judicially as well. So although it, you know, is better for you guys from a time perspective to do a non-judicial sale, that first mortgage also has those same rights. So usually what I see, or what I try to do is there's a couple sites as the attorney when I'm handling, or when I get a file in, whether that be at the due diligence stage or at the foreclosure stage. There's a website called georgiapublicnotice.com, and that website lists like all the counties. It's like a central repository of any notice of sale that's out there. So if the loan has already been foreclosed, or is in the process of, you know, being in foreclosure, and the first is not current, then you'll find it that way. Of course, there's also credit reports. You know, if they're reporting on credit on the trade line, then you can check there too to see if they're late or they're behind. You know, seek a first payoff from the, you know, from whoever you can get it from. I don't know if, you know, how you guys handle that, or if you do during your due diligence process, but that is another way that you can go about it as well. And the other thing being, if you are not able to find it on the Georgia Public Notice site, every county in Georgia has one newspaper that they're allowed to publish in. It's called a legal organ. And that legal organ is set specifically. So you can just Google, let's say, Gwinnett County legal organ. It'll come up with a Gwinnett Daily Post. You go to their website, check their legals, and you can, you know, sometimes find it that way as well.
Great. Okay.
So your big goal is making sure that your title search doesn't come back, or your O&E doesn't come back with any deeds under power of sale, or any, you know, information regarding the a pending foreclosure sale, and that nothing's indicating that it's delinquent, because they can foreclose just as fast as you can.
Okay.
In Florida, it's a little different. In Florida, because the process is judicial, a lot of times the cases are really easy to find by just searching the county websites to determine the status of a first foreclosure, if there is a foreclosure pending. And, you know, my clients make those decisions on individual bases, just depending on where the first is in its process. Is it dismissed? Is it current? You know, are they at trial? Is it at auction? Sometimes as a second, they will bid at the sale on the first to protect their position. So you kind of, you know, get things like that. What is this thing telling me that there's 2 more people on? Is that what it's telling me?
I guess.
Okay. I keep seeing like something pops up and there's like little ellipses and it says 2, and I'm like, ooh, is somebody else on, or what's going on here?
There are 6 of us now.
Oh, there's chat. That's what it is. Okay. Yeah, georgiapublicnotice.com. So it is spelled out Georgia, but you can find it pretty easily if you just Google that. Okay, so Florida, judicial state, you always have to get a judgment entered in court. What does that mean? You've got a civil procedure process to go through. So essentially, I think for the most part nationwide, your civil procedure process is the same. And there's going to be little nuances here and there, but what they're going to be is this. You get the file in the door this is as an attorney. I get the file in the door, I review the collateral, I file a case. I then have to notify everybody that I'm taking the property away from, or potentially affecting their lien interest by service of process. So I either need to hand them physical paperwork, or in Florida, you're allowed to also publish if you're not able to find somebody. And then once everybody is notified of the action that's required to be notified, then I proceed to judgment. There are several ways to proceed to judgment depending on the procedure of the case, whether it's contested, uncontested. The 2 big ones in Florida are going to be summary judgment, which is usually for uncontested cases where everything can just be done through paperwork and it goes decently quickly. or if it's contested, we generally do non-jury trials where a witness comes. Regardless of that middle process between serving the paperwork and the judgment hearing, it results in that final hearing, which ends in a judgment. Whether that's a judgment for you granting the foreclosure or for the defendant dismissing the case, just depends on, you know, the way the case goes forward. Obviously, if your ducks are in a row and there's nothing wrong with your paperwork, then, you know, you're fairly certain to get a judgment entered. I can't say that I've had too many instances where I filed cases where the case has not resulted in a judgment in the favor of the bank. Florida is, although they do, you know, hold your feet to the fire as far as the paperwork is concerned, most of the time, you know, it ends relatively well for you guys. So I'd say I've maybe seen in my career 2 or 3 cases that have been dismissed legitimately. So that doesn't include lack of prosecution dismissals because it's on loss mitigation hold or there's a bankruptcy, or, you know, when the bubble burst kind of happened, everybody stopped doing anything because they were all freaking out about bad paperwork, and cases were being dismissed left and right because the bank failed to show up at hearings or failed to provide the proper paperwork or answer the court's orders and things like that. So once that judgment is entered in Florida is when the auction is sold, or the auction is set. And then once the auction is set, that's when the property is sold. You end with a certificate of title in your name. And again, that does not mean that it's free and clear of all liens. It means it's free and clear of anything that is subordinate to you. So in a second mortgage situation in Florida, you're usually going to have a first mortgage obviously in front of you. And then more oftentimes than not, you'll have an HOA in front of you. I won't get into the nitty gritty about that, but if somebody has questions about the HOAs specifically, then, you know, we can, you know, discuss that as well. But generally speaking, in Florida, HOAs subordinate to institutional first mortgagees, but they do not subordinate to second mortgages. So that's kind of the standard. And then depending on the actual declarations that the HOA drafted, there could be additional subordination to a second mortgage. And I do have a couple of those cases, but they're not as common as subordination to only a first.
Quick question.
Oh, yep, go ahead.
You specifically said that an institutional first. What if it's a seller finance first?
Institutional first mortgages are the standard language, but it all depends on the language of the declaration. So your HOA, essentially how that process works with HOAs is this. At the time of development of a parcel, the HOA or the developer, you know, forms the neighborhood, forms the association surrounding it, or, you know, his board forms the association surrounding that. And they write a declaration of covenants or, you know, employ an attorney to write one. That declaration of covenants will list out where the entire property is located, like the entire neighborhood. It'll indicate, you know, who's going to pay for roads. It'll indicate how assessments are requested. It'll indicate how people are approved for purchase of a property. All those things will be addressed within that declaration of covenants and its amendments thereafter. So part of where I usually look for that language as to what is subordinated to the HOA or what is it superior to a second mortgage is there's a section in there that addresses assessments. And as those assessments are addressed, it'll indicate that the assessments can't accrue against the property and against the owner. It'll indicate that those assessments are, you know, collected on a monthly basis, that special assessments can be done, you know, based on a vote or however they decide a special assessment can be assessed. And then it'll indicate a foreclosure process for those assessments. In that area of the declarations, it will indicate what it subordinates to. So it'll say, you know, the lien for assessments, or it'll say you have to record a claim of lien as to the amounts that are due and owing. And then once you do that and you write, you know, XYZ demand letter, then you can proceed with foreclosure. And then it will say in there, the claim of lien relates back to the HOA declarations, which are always recorded first when the neighborhood is established, which essentially cuts off anything that's recorded. So your first mortgage is recorded after that. Your second mortgage is recorded after that. Your, you know, credit card judgment is recorded after that. That declaration is recorded when the neighborhood is made. So in order to incentivize first mortgages to lend money, they put that institutional first mortgagee requirement in there. So that will either say institutional mortgage, it'll say institutional first mortgagee, it'll say institutional mortgagee, it'll say something indicating that, or it will just plainly say first mortgagee, second mortgagee, or mortgagee. The other places in the definitions, where the definitions will list out what defines a mortgage, for instance. So if you get to that section and it says institutional first mortgagee, then you may want to check with somebody and just double check to make sure on an owner finance situation that you'll be okay there. That said, a lot of that, I believe, is usually covered in the closing, just because the HOA has to approve the buyer that's purchasing, or if it's a refinance transaction, sometimes it'll be covered by not that purchase money transaction, but institutional first mortgagee, or first mortgagee will encompass even owner financing or seller financing in those situations. So it's really just depends on the language of the declarations and then the amendments thereafter. So how I usually do it is I start with the amendments, because if there's an amendment, I want to know, you know, they're pretty easy to look through. They take a, you know, they're 2 or 3 pages versus 150 or 180 pages of the main declarations. And if they're not included in the amendments to the declarations, then you want to go back to the original decks when the property was formed or the neighborhood was formed. Does that answer the question?
Sure does.
Okay. So in Florida, original note is the big thing to have. So we're an original doc state here. It doesn't matter whether you have the original recorded mortgage. The county could care less. The judges could care less. I can get a certified copy of the recorded document out of the official records of the county, and it is exactly the same thing as having an original. But what does matter is having that original note and making sure that that original note is properly endorsed. So making sure that you have a chain of endorsements from original lender on the first page of that note, all the way through to blank or to your name is how it works. So to the extent that you guys are not too familiar with endorsements, endorsements they run on a note, on a promissory note, just like a check. So if you say pay to the order of Bob Dylan, then Bob Dylan's the only one that can say pay to the order of Kimberly Banks Fawcett. And then Kimberly Banks Fawcett is the only person that can say pay to the order of blank or pay to the order of Erin Quinn or whatever the case may be. So you always want to make sure that you're reading those endorsements properly to make sure that there is no broken chain. If you have a broken chain in Florida, it is an uphill battle. So whether you're missing the original note in entirety or you have a broken endorsement chain, that allonge or that endorsement is part of the original note, and it can become an uphill battle for you. Sometimes it is rectified by assignments. But if you have a situation where you're looking at, you know, a loan in Florida, my suggestion would be that you always, if you're not comfortable with endorsements and not comfortable with, you know, a potential broken chain, that you seek out an attorney to review your options with you so that they can tell you how that will wind up. The good thing is only about 3% of loans actually have lost note affidavits or are missing the original note. The overwhelming majority of files will have a proper endorsement chain and will be an original note because of the stringent requirements in Florida regarding lost notes. So if you do have an affidavit of lost note file and the file is dirt cheap and there's 17 assignments on it and it's $5,000 for $100,000 UPB, it's probably too good to be true, and there's probably a reason why there's 17 assignments. So again, that's, you know, where you would want to call on somebody just to make sure. generally speaking with these things, and I think this is probably the case anywhere, if you've got something that is, you know, assigned time and time again, over and over and over again, and it seems to be like it's too good to be true, it probably is. So again, reach out if you guys want, you know, have anything that you're looking at in Florida that you have questions on. And in Georgia, the opposite of that, or I guess not the opposite, but the sister situation there is assignments. So Georgia, they give absolutely no care in a non-judicial foreclosure whether or not you've got the original note. Everything relies on the assignment of mortgage chain in that situation. They do not care what that note looks like. I don't need it when I'm foreclosing. I don't need to see it. The only time that it becomes a problem or becomes needed is if there ends up being a judicial foreclosure. So, but what you don't want to do in these kinds of situations is say, oh, well, there's a power of sale language, so I'll just proceed with a non-judicial foreclosure and we'll be fine. That's great, and that works most of the time. Your caveat to that is that in Georgia, although you can proceed with a non-judicial action, they do have the right to bring an action against the bank to stop the foreclosure. A wrongful foreclosure is a cause of action in Georgia that is used to stop the non-judicial process. It is not often used. In fact, in the 2 years I've been handling these cases for 5 or 6 institutional clients, I don't think, I haven't ever had to attend a hearing for a temporary restraining order and an injunction to stop a foreclosure sale to file a wrongful foreclosure case, or have the borrower file a wrongful foreclosure case. But it can happen. So you do want to try to shore that up when you start looking for something in Georgia, specifically because once you are generally done buying the loan, the servicer / owner goes MIA and they're never going to give you anything again. So at least making sure that you've got a copy of that note is important in Georgia. And it's really the 1% of cases that would end in a judicial sale if they have power of sale language in the documents, but you just want to make sure that you're accounting for that. As for contract for deeds, so I'm getting a lot of questions lately about contracts for deeds in Georgia and Florida, and especially Florida, it's been problematic for the smaller investors that I've been involved with. The biggest concern I have is that they're not recorded. And the concern is that contracts for deeds, agreements for deeds, anything of that nature in Florida is not handled through eviction or conversion or forfeiture. Wait, did I say forfeiture twice? Forfeiture, eviction. Yeah. So it's actually handled as a foreclosure. You have to do a full foreclosure in order to obtain title back in a contract for deed. That is not just a marketability requirement, it's an insurability requirement. So when you get into REO and somebody's trying to buy title insurance on that property, if you have deed to the property and they suspect that it is subject to a contract for deed or an agreement for deed, they will require that you complete a foreclosure on that. So you're not going to cut any corners in Florida by proceeding with a contract for deed rather than a mortgage. It's going to go through the same judicial process. And oftentimes, because they are unrecorded, then you get into situations where you're subject to any lien that records ahead of that agreement for deed. So I have a situation right now where a owner of a property, like a creditor owner of a property, had their warranty deed to them, and they had their unrecorded contract for deed, and then but they did not ever put it in the official record. So they had their warranty deed, and then the county came in and said, oh, hey, here's $100,000 code violation lien against you. And they recorded it. Well, guess what? Contract for deed's not recorded. Once we record it, it's still subject to that code lien because the contract for deed does not relate back to the warranty deed in that situation. So making sure that those documents are recorded is important. The other thing being, as attorneys, we aren't seeing too many of those, and we're not sure how the courts are going to treat them. So most situations for me with contracts for deed in Florida have ended in quitclaim deeds from the borrower essentially deeding that property back in lieu of foreclosure for a nominal fee. So I've had a couple that have gone back for, hey, buyer, we know you've abandoned the property, $200 and I'll sign it over. Or $200 and I'll forgive the debt. You just sign over the quitclaim deed to me. And that has been one of the more popular ways for me to deal with them. But if you get a situation where a buyer or a borrower wants to keep the property, then you have to go through that foreclosure process, and then you've got to worry about those recording priorities. So in contrast, in Georgia, because it is a title theory state, your contracts or deed, again, are not popular, and they may kind of require some trial and error. I think that they can be done through a forfeiture action, but again, because they aren't popular, or an eviction action, I should say, it's gonna be a little trial and error with respect to a judge and what they're willing to do and not do in a contract for deed situation. So versus, your security deeds in Georgia, you have that power of sale language, you get through that non-judicial foreclosure, you proceed right into eviction, you're done in 90 to 120 days with everything, and it's over. So that's kind of what we're seeing on the contract for deed front right now. Does anybody have any questions about that?
Nothing to add on it.
Okay. All right. So lastly, just, quick for you guys, the difference really between Florida and Georgia law as far as where to find things is that Florida actually has really 3 bodies of law that you have to address. And that's from, I guess it's technically 6 because it's going to be federal and state law. And then you have common law, which is based on things that are created within the cases. So for instance, certain causes of action are created by case law that are made by judges. So a judge will decide a case and say, these are the elements of a cause of action for, breach of contract. Or then you've got, so that actually comes out of case law. And then you've got case law, which provides certain rules surrounding that and interprets certain statutes. So you've got case law that says, the statute on 701, .21 says, XYZ happens, this is what that means, this is how you have to go about that. So it actually interprets the statutes as they're written by the legislature. So your case law is your body of judicial law, along with your common law, those 2 specific issues, the common law being setting the causes of action that are not listed in the statutes, and then your case law interprets that common law. Your statutes are actually written into the body of law by the legislature, and the case law then interprets those statutes as they're written. So the judiciary will interpret those statutes. In Georgia, everything in Georgia is codified in the statutes. There is no common law from a sense of all causes of action are in the Georgia statutes, the official code of Georgia, but you do need case law to interpret those statutes. One of the things that I've noticed as an attorney that practices both in a judicial and non-judicial states is how much more law and interpretation and how much newer it is in Florida versus Georgia. Because generally speaking in Florida, because the lender has to file and proceed with a judicial case and actually get a judgment in a court of law, and the borrower doesn't have to pay anything to file suit, you see tons of cases and tons of defenses that are interpreted 6 ways to Sunday. In Georgia, because the borrower has to file suit in front of filing fee and pay an attorney and all of those things up front, there's not a lot of case law that specifically deals in the area of real estate law. I can't speak for the other areas, but I have noticed that a lot of my interpretation of statutes and certain situations in Georgia law are based on cases that are from like 1986, 1963, 1947, 1874. So that's kind of where I see the difference there. So I do prefer and I love to have things in Florida from that perspective, but obviously Georgia from a litigious standpoint is much more easy to navigate because we don't see many cases. I think out of the probably 300 or 400 cases that I've done in Georgia, I've maybe had 2 that I've had to file suit those were just reforming the mortgage and reestablishing the mortgage that wasn't recorded, or security deed, I should say there. Any other questions on foreclosure right now? The difference is judicial, non-judicial? No?
No?
All right, see if we can move on here. So next is bankruptcy. This is going to be quick and easy. Both Florida and Georgia fall under the 11th Circuit, which is the federal circuit. And most of the jurisdictions around the country are generally the same when it comes to bankruptcy. So there's not a ton of difference, like usually in a Chapter 13. It's going to be a reorganization where they repay up to 5 years. They repay all of their debts. So they basically say, you know what, I've got a ton of bills. I don't know how to pay these off. I need some help structuring that. They go through that process. They provide a plan on how they're going to pay it off. And then, you know, everybody kind of looks at it and says it's feasible, not feasible. You know, everybody's getting their fair share. And they then reorganize and confirm that plan. And then that debtor pays over a period of 5 years. They have to complete that plan in order to be discharged. Anything that is not completed out of that plan is subject to a motion for relief because the debtor didn't comply with their intentions on the reorganization, and you can essentially have a property taken out of the bankruptcy estate and you can proceed on it separately, even though they continue in their reorganization payments along the way if they fail to make one certain obligation. So it's not an all or nothing. It can be piecemealed out of the Chapter 13 depending on what the creditor is receiving. And then in a Chapter 7, those are generally liquidations where they're basically trying to write off all that debt. They're not trying to repay everything. They just want to get discharged from any personal liability. And in a Chapter 7, upon discharge, usually the bank has, and I say the bank meaning you guys as well as investors, usually the investor has the freedom to move forward and they have relief at that point in time, unless the debtor is current on the loan or they surrender the property. Obviously, you'll still go through the same foreclosure process, but you won't have to end up potentially fighting the borrower. Those are short durations, are usually 90 to 120 days from the time they file to the time of discharge. And only those debts that are in either of those bankruptcies are discharged in the bankruptcy. So if they don't include something in the estate, if it's not included, there'll usually be some type of provision providing relief for that. Does anybody have any questions about bankruptcy overall? Okay, so quickly, one last thing on that. Usually in a Chapter 7, what I see occur is a motion for relief on that Chapter 7 because the property is surrendered. Or if they intend to proceed with it, then they'll try to work something out or they'll bring the loan current. And then in the event that they are not current, you file that motion for relief, or you can wait for discharge and have the debtor, once they're discharged, you can then proceed or attempt to modify the loan. In a Chapter 13, the very first 2 things that you usually end up filing are a proof of claim indicating how much you're owed and a objection to plan. I'm going to try to stop saying you guys, like I'm totally hearing myself and I need to stop. But so objection to plan, if the plan is objectionable in some way, usually they try to cram down your interest rates, or they want to treat you as unsecured, or they want to surrender the property, something, they're not providing enough money to your loan and you're trying to protect yourself. So you're going to object to that plan and you don't want that plan to be confirmed because you want to be paid in full. And then the POC is just essentially an affidavit indicating how much you're owed and what the arrearage was at the time the petition was filed. In addition to that, in a Chapter 13, again, motion for relief can be filed. That's another type of referral we see come into our office when the debtor is not living up to the plan, not providing for the creditor in the Chapter 13 plan, or otherwise is not sufficiently protecting the creditor. So we do see some state law issues in bankruptcy court, specifically federal court, there's jurisdiction, but state law will control for property law. So anything to do with real property, for the most part, is going to be controlled by state law, and the federal courts are going to interpret that in the context of the state law. So there won't be federal real property laws for the most part. There's federal credit laws and debt laws and credit secured by real property laws, but they're not specifically real property. All right, due diligence and the chiller font. This one, again, we talked about the price thing. Does it seem to be good to be true? You do want to check and make sure that what you're looking at seems like it's a good deal, but not the most amazing deal you've ever seen. And I can't believe they're giving it away for so little. And why are they doing this? Always make sure that your stuff is in order and making sure that your price fits generally what you're used to seeing as an investor for assets. As you guys grow, obviously with pools, sometimes they're going to have, cheaper price points. You might be able to get it for, I don't know, 30 cents on the dollar if you're buying a pool of loans versus 40 cents on the dollar if you're buying one. So just make sure it's generally within the realm of what you're looking for so that you're not getting something that potentially has stuff that's wrong with it. Collateral file, again, original note, make sure it contains all your endorsements. Make sure your original mortgage is recorded. You are not going to see recordings with contracts for deed. I have not seen one file come into my office with a contract for deed in Florida that's been recorded. So this is more on the original mortgage aspect of things. That said, a security deed in Georgia will be recorded. Is there a full assignment chain? Always look for that. Full assignment chain, full endorsement chain. Chain, basically chain of ownership on the original note, chain of ownership on the original mortgage. If you have a break in either one of those and you don't know whether that will affect the action, if you intend to foreclose on it, I would reach out to an attorney that you trust to give you that answer or to review that file for you. And then, is there a lender's title policy? I see a lot of commitments come through my office where they get the collateral file and there's a title commitment in the file. That is not the same as a title policy. That commitment says, if you do X, Y, Z, I will insure I will insure the loan. But that doesn't mean that the policy was actually executed on the back end, and that's what you need. So make sure that you're getting that title policy with that, if that's what you want. So if you are okay without having a policy on, for instance, a second mortgage, and you want to disregard that, then fine. I would just make sure that if you're intending that it be covered by insurance for the mortgagee or the lender, that you have that title policy in there, or that they provide a copy of it. I have been able to track policies down through commitments a couple times, but with a lot of these defunct title companies out there and things not necessarily lining up with the actual insurance company on the back end, or the underwriter on the back end, sometimes we do have problems finding them. And if that is the case and you just have the commitment, then you may be in a situation where you're not able to find that policy and not able to make a claim. I did have, speaking of a title policy, this is something that's not in here, but I'm going to go ahead and address it anyway. I did have a note investor come to me recently wanting to discuss the difference between claims made policies and occurrence policies from an insurance, like a property liability perspective. And what happened is the prior lender had a claims made policy on the loan that essentially, or on the property, excuse me, it was a forced place policy. And that claims made policy was out there. There was damage to the property that he wasn't aware of. He purchased the loan, found the damage on the property, tried to make a claim on the policy, and the insurer said, too bad, so sad. This is a claims made policy, which ends once the loan sells. So instead of, so when ABC sold it to XYZ, ABC was the insured on that claims made policy, XYZ was not, even though XYZ was the successor to that note purchase. They refused to honor the insurance policy because that's specifically the type of policy that was done, versus an occurrence policy can be successors to the lender that sold it prior. So ABC sells to XYZ, occurrence policy, XYZ can then file a claim based on something that occurred prior to the sale of the loan or the purchase of the loan. So another thing that I tend to look at when I complete a due diligence for a client is going to be prior cases. So in Florida specifically, what happened in that prior case? Why was it dismissed? Or was it dismissed? Was it dismissed because there was a loan mod? If that's the case, fine. But I need to know that because I need to know if there's a loan mod out there, because the borrower is collecting under that modification now, not the original terms of the promissory notes. Or was it denied over something fatal? The mortgage isn't attached to the property. There's an error in the legal description. The default date, the judge determined that the default date wasn't proper. The bank breached the contract and is being denied the equitable relief of a foreclosure. Why was that case dismissed? Luckily in Florida, almost every single county is online now. The state mandated e-filing not too long ago. We do have some issues sometimes pulling up old cases, but I would say pretty much everything since at least 2010 and forward is online. And most of the time we can go through the court system and find out one way or the other too. And those major documents, the lis pendens that starts the action or that's recorded when the action is started, or the dismissal will include the language there, and both of those are recorded in the official record. So I always look at what the process or what happened in the prior foreclosures. A good example of that was when I received, it wasn't actually a due diligence, it was a client that referred a foreclosure to me, and I found an old case and the borrower said, I modified my loan, I sent the modification in, I made my payments every single month, and then the bank sent me a demand letter saying that I didn't pay everything. And I paid it. And I never received any statements indicating that they needed additional money. And what ended up happening was the bank boarded the modification, never sent the borrower statements after the fact indicating that he had forced escrow. So he assumed he was paying escrow in the end of the year like he had been before he defaulted. And the bank essentially was collecting his monthly principal and interest payments and applying them to principal, interest, taxes, and insurance. So in that situation, luckily, I also noticed that he didn't file the grievance process to handle that situation with a prior bank, and he he breached in anticipation of their breach. So they sent him a demand letter. He stopped making payments. So instead of continuing those payments and having the bank reject his payments after they got to a certain point, he just said, oh, well, they're about to breach, so I'm not going to pay. And so I was able to overcome that potentially fatal error. And it probably should have been something that was addressed in the original foreclosure action, but for whatever reason, it was not raised, and the case was dismissed when the borrower raised those defenses. So looking for things in that prior case are definitely something you want to look at. Bankruptcy, has the debt been discharged? Did the prior servicer protect the interest? Did the lien get stripped? You want to make sure that you're looking at bankruptcies, because if you are purchasing a loan where the mortgage was stripped from the property, then you're purchasing something that you can't seek foreclosure of the property, or you can't take a secured interest in. You're just buying the debt. And at that point, all they have to do is, get discharged in a bankruptcy to get rid of you. So you want to make sure that there has not been any kind of stripping of the lien that you're trying to purchase. Discharge of the debt. If you don't care about that, if you don't care about being able to personally recover from the borrower, you're just interested in, potentially recovering from the property or making it reperforming and having them reaffirm the debt in the form of a modification, then that's fine. But just make sure that you're aware of that and you know what the risks are with respect to potentially a reaffirmation agreement not being done or with the debt being discharged before you make that call and you purchase the loan. Then with the prior servicer protecting the interest, again, another, I guess, scenario that I had come across my desk fairly recently was a person that purchased the debt while it was in a Chapter 13 bankruptcy. That Chapter 13 bankruptcy had a plan. The plan was confirmed. The debtor was making his payments. They got to the end of the bankruptcy. They filed a notice of final cure, which is what the borrower files when they've completed their plan. The lender never objected to it. And it turned out that the plan never addressed the arrears that existed at the time the petition was filed. So about $50,000 of this $250,000 property was not able to be recovered because the prior servicer never objected to the plan, saying it didn't provide for the arrears, never provided an interest rate for the arrears, and they never objected to the final cure, indicating that the arrears were still outstanding. So that case is actually, I'm kind of watching it right now because it's being litigated on the back end. They're trying to unwind that situation. And that was because the prior servicer didn't protect their interests and they didn't check what the actual status of that Chapter 13 bankruptcy was and what was actually accounted for in the plan. Anybody have any questions on this slide?
I have a quick one.
Yep.
I recently had, now granted this was Ohio, but I recently had a borrower who had gotten a discharge from his Chapter 7. So he was no longer liable for the debt personally, but he really wanted a loan mod. And I had trouble with the servicer because the servicer would not send him statements because he had gotten that discharge and hadn't reaffirmed the loan. What am I supposed to do in that situation to fix it?
I don't know the laws surrounding in Ohio as far as the sending of statements are concerned. My first thought is that federally, you can still send mortgage statements even if they're discharged in a bankruptcy, as long as they indicate, or there's the caveat of this is for informational purposes only if you've been discharged in a bankruptcy and we're not attempting to collect a debt from you. That said, for you specifically, you can still seek reaffirmation. I don't think you are required to send statements to seek the reaffirmation. I think you just have to reach out to them, and you just want to ensure that whoever is, if you're handling that loan modification yourself, or you're doing the loss mitigation aspect, or somebody else is negotiating that loss mitigation, that they ensure that they're working with a bankruptcy counsel that provides for the correct reaffirmation language in the modification.
Okay.
Does that kind of answer that?
Yeah.
Okay.
Just so you know what we ultimately did, it was so screwed up on multiple aspects. So we just did a whole new loan.
Well, that works too. You can do that. Yeah. That said, I can check the FDCPA requirements. I don't know that I've ever had that specific situation happen to me, so I don't know that I can say with 100% certainty on the statements aspect. I'm fairly certain that you're fine to send statements even if the bankruptcy is discharged, as long as they're for informational purposes only. But the state law there too is, for instance, Florida has the Florida Consumer Collection Practices Act, and it is more stringent than the FDCPA. So we have to obviously make sure that we're complying with that state law regulation as well.
Gotcha.
All right. Anybody else? Alrighty. Title issues. So we already kind of talked about the HOA and whether it's superior to your security interest. So I'm not going to go back into that issue. That is, again, generally speaking, in Florida is going to be, the HOA is going to be superior to the second, but not to the first, but there are exceptions to that. So it's just a case-by-case situation. Correct lien position. Make sure that if you are buying a first mortgage, it is in the first mortgage position. That means that there are no open mortgages ahead of yours. Your O&E report should indicate that. I have actually a well, I guess this kind of goes into a superior lien as well, but I'll kind of, I guess, address them together. So superior utility liens, for instance, Florida, in Florida, Chapter 162 liens are code enforcement liens. The counties and cities tried to enforce them as super priority, like taxes, and the state finally came out, or the courts finally came out and said, no, that's not the case. But Chapter 159 liens, which are water sewer liens, any kind of, any specific type of utility lien out of that Chapter 159, are considered super priority liens. So knowing whether a loan is super priority in your jurisdiction, which essentially means regardless of where it's where it's recorded, it's always going to take a priority over the mortgage, and the ownership interest of the borrower. You want to make sure that you're making, checking for those and making sure that you're in the right position there and that there's nothing there. So correct lien position, whether it's a mortgage or a judgment. I have a client right now, sent me an O&E to take a look at. He bought a property. I look at it. I see that the borrower took title to the property in, let's say, 06. And then down the road, he has a mortgage. Let's say he purchased the property, took out a mortgage at the same time in 06. And then 2 years later, a car loan comes in, files suit to obtain a judgment against them. They're not able to repossess the car. They get a monetary final judgment. They record that final judgment against the borrowers, and that lien is sitting out there just waiting for him to move out of that property, because this was in the state of Florida, and the homestead exemption stopped them from being able to levy that property and sell it to satisfy their lien. So he just got this car loan lien sitting out there. Then he goes and says, you know what, I want to refinance my mortgage. So 3 years later, refis. For whatever reason, the mortgage company never deals with that car lien. They only pay off the first mortgage. So the first mortgage from 06 is paid off. Lien is now recorded in 2008, and now refinance mortgage is recorded in 2011. Guess what's ahead of your mortgage, even though you're technically a first position refi? The car lien. So in that instance, there's a couple ways to try to work it out. Right now, we're in the process of discussing with the attorney for the car loan judgment. We're trying to buy that judgment from them for cents on the dollar, so that essentially the person that purchased the loan is going to end up having to pay out of pocket a little more to take care of that, but then they'll be able to what's the word I'm looking for? Recover what they paid when they foreclosed the property based on the mortgage. So the lien will basically stay out there until either A, the borrower moves out and it becomes non-homesteaded property, or it's satisfied and paid off. So you just want to make sure that you're in your correct lien position. Really what that boils down to is that there should be nothing between you and the deed unless you are less than a first mortgage. So if you're a second mortgage, you can expect the first mortgage and the HOA potentially to be between you and the warranty deed by which the borrower took the property. If you're a first mortgage, there should be nothing between you. Any questions about that? Another big one is someone on a pre-mortgage warranty deed that didn't sign the mortgage. In Florida, again, with the homestead protections, if you are on the deed to the property, you have to sign the mortgage. If you don't subordinate your interest, and your interest cannot be foreclosed. So you always want to make sure that anybody on the deed to the property is also on the mortgage or the security deed. They always need to sign that contract allowing you to foreclose. That contract is what allows you to take the property from them. So if they're on that deed, you're owning the property with them, and if they're not on the mortgage. So I guess example, I'm on the note to my property. I'm the one that is responsible for the debt. So I have to pay the mortgage company. But when I took out the loan, to purchase the property, I was taking title in the name of myself and my husband. So the mortgage company required that I have my husband sign the mortgage, even though he didn't sign the note, because in order to take that ownership away from him, he had to sign the mortgage. It's the same thing if I'm married, and this is state of Florida specific. If I'm married and Erin Quinn takes out a loan and she wants to buy a property and it says Erin Quinn, a married woman on the deed, doesn't name who her spouse is, and then I sign the note and I sign the mortgage and it's my homesteaded property, my husband has an ownership interest in that property that cannot be foreclosed. That's on a homestead property. So if the language in the warranty deed or in the mortgage specifically indicate that it is not my homestead property and it's my separate property from my husband, then I can get away with that. But anytime in the state of Florida that you have a married person that owns property, you want that spouse to also sign in the mortgage. So you'll also see in situations where there's divorce in Florida, where, person A and person B are in the process of a divorce, they're separated, but because husband moved out of the property and wife refis, if their divorce is not finalized, it does not matter if husband is living there or not, he's going to be required to sign that mortgage and he's going to sign off on it, period. Because he's on the deed still, or he, by virtue of his marriage to her, has that homestead interest in the property. And then lastly, legal description errors. I kind of went backwards on this, but I wanted to address the HOA situation first since we'd already talked about it. So legal description errors. I've got a case right now. All the legal descriptions through the whole chain of deeds through the mortgage all say lot 5. And if you read the description of the actual property address, it's lot 4. So now we're having to seek reformation of that document to actually encumber the property that they meant to encumber. And so you always want to make sure that there's no legal description errors. It can be especially concerning when you have these huge, long legal descriptions with meets and bounds, degrees, minutes, seconds. We have a lot of those that start at the iron pin and end at the cow and then go to the stop sign. And then a circular curve of 90 degrees. That kind of stuff can be very tedious, but fixing those legal description errors is an issue. A lot of times they can be fixed. However, what it does usually require is copies of certain portions of the origination file at the very least. So a loan application or a TILA disclosure indicating that you're giving security interest in a specific property address, an appraisal appraising the property with a house on it versus an what's the word I'm looking for? An undeveloped lot. So that's a situation where I have right now where lot 5 is 0 Worth Street and lot 4 is 402 Worth Street, which is an improved property. So the mortgage encumbers the unimproved 0 Worth Street instead of the improved 402 Worth Street. And we're having to handle that through reformation. And unfortunately, my client doesn't have the origination file, doesn't have the origination appraisal. And I'm in a position where they have a title insurance policy and I have no documents to provide that title insurance company in order to make that claim and have them pay to fix it, the insurance company, or help the client fix it judicially. So they're in a position right now where there's potentially a complete loss of that security interest because they don't have copies of the origination documents. At the very least, I would ask or request that you get a copy of the origination appraisal, a copy of the loan application, and a copy of the TILA disclosures that indicate that they're giving a security interest in that property. Any questions on that?
No questions, but I did enjoy the cow reference.
I know, right? I got to make this somewhat not dry. Cases in progress. If you are buying something subject to a foreclosure case already, especially in a judicial state, did they do the prerequisites, i.e. proper breach letter? This is a very common situation. what I have a lot of clients do is they list the borrower in the system as the person that signs the promissory note, because they're the one that they have the social security number for. They're the ones that are on the debt, but not on the mortgage. And then a breach letter goes out to just that person that's on the note. The problem with that is that there are just as many mortgages that indicate that notice to one borrower is notice to all, which would cover that scenario, and ones that require that anybody that signs the mortgage be provided a breach letter. So I have several clients that have had to re-breach cases multiple times because they failed to include everybody that's on the mortgage on that demand letter. So making sure that anybody that's on the mortgage is noticed in the demand phase is very important, especially when you get into a case like Florida. Oh, hey, there's a trial next week. I'm going to buy this debt before the trial. Then you get to the trial and you only have a breach letter to Susan, but you don't have a breach letter to Herb. Well, now Herb is raising the breach letter as a defense, and you have nothing that you can do against that because that breach letter was a prerequisite to your case. It's not as bad in a non-judicial setting just because all it requires you do is to cancel the foreclosure and just re-breach it. Or really, the radical side of that is you say, well, they have to raise it and they have to file a case indicating that we wrongfully foreclosed. So we'll just wait and see if they raise it. But then again, you also want to, keep in mind that you'd be on the hook for attorney fees if they raised it and it was properly raised. Payment histories. This is another one of my albatrosses in my life. Trying to get as close to a life of loan pay history as possible in judicial states is so important. There are so many cases where we take a case to judgment. The standard in Florida for boarding and incorporating records includes a specific boarding process, the QC of a boarding process, that the witness be knowledgeable of that boarding process to essentially vouch for the accuracy of the records for the existing servicer and existing investor. So if that witness cannot provide that foundation, then the only alternative to that is the life of loan payment history. So making sure that you don't have gaps in the payment history is important. At the very least, you want to have a payment history that covers the date of default. So for instance, if your payment history or your default date is October 1st, 2013, you want a pay history that at least goes back to September 1st, 2013. But ideally, you'd always have that life of loan or as close to possible as you can get. Any questions on that?
What about if you have a gap and you go to foreclose and they contest, can you just waive the payments that they're claiming they made and you have no record of?
I think from a judicial perspective, it'll be jurisdiction specific. In Florida specifically, you can, if the judge lets you, is the answer. Mm-hmm. So what you can do as a compromise is say, yeah, you can consent to judgment. I'll waive those 2 years of payments if you consent to judgment. Will the borrower take it? Maybe. Will the judge find in your favor anyway? If you have the boarding and incorporating process down, then your pay history regardless of the gap may be accepted as accurate records. So it just depends. It's definitely not a best case scenario.
Okay.
So horror stories wise, we did talk kind of briefly about the case with no objection to the final cure, which had the Chapter 13 plan that didn't account for the 50 grand in arrearage. That's one of them. Litigious borrowers. So having your ducks in a row is really important, especially when you have pro se defendants that'll throw just about anything at a foreclosure so that they can stay in their house for free. Actually have a borrower, and this is where it kind of looking at the old cases kind of helps you guys to see what you're getting yourself into. Actually, 2 cases. I have a borrower from a September 1st, 2007 default from my firm that I left in August of 2013 that still includes me on every single pleading, that still lists me as a creditor every single time he files bankruptcy. He's filed bankruptcy multiple times. He's filed hundreds of pleadings. I'm not kidding you when I say hundreds of pleadings in the foreclosure action itself. Making sure that you're not getting into one of those situations is important. You can't always bet on it, but if you see an old foreclosure and the case lasted 5, 6, 7 years and the person was pro se or had a specific litigious attorney, it might be something that you want to account for, in your purchase of the loan or just in your timeline for when you're going to actually see return on the case. There's also a situation where some defendants, if you see a defendant with multiple attorneys, so 5 attorneys have withdrawn from the case, they're going to be a nightmare. The borrower is going to be a nightmare. I have a case actually right now that I just filed, and I was looking at the prior cases before I filed it because the borrowers had actually been ordered by the court or enjoined by the court from filing any cases against several different entities, including like Bank of America, filing criminal cases against those entities, any of their attorneys, any of the firms that handled the matter on the plaintiff side. And they were finally enjoined from filing anything pro se. So the court actually determined that they would no longer be able to file pro se pleadings and that they would be required to retain counsel if they wanted to file anything further. There was fraudulent warranty deeds associated with that. They were enjoined from further transfer of the property. So there were a lot of things involved, but looking at some of those old cases in that jurisdiction will help you at least know what you're up against if you're going to purchase a loan like that. And then lastly, missing powers of sale. So I kind of harped on the fact that in Georgia, or any non-judicial state, you want to make sure that you have the golden language that allows you to sell the property non-judicially. And in Georgia specifically, that power of sale language is it. So I do have a case right now where the power of sale, funny enough, a prior firm took the file all the way through foreclosure sale and then told the bank the sale was invalid because they didn't have a power of sale language in the security deed. So then it came to my office, obviously after they fired the attorneys, to reform those documents to include power of sale or completed judicial foreclosure. Any questions on this slide, guys? Almost done. Oh, we are done. Look. Yay. So that's kind of it. I just kind of wanted to give you guys the ups and downs and the differences between so that you have the ability to at least look through some and pick out things. And the big thing about this, guys, is really just to make sure that you're able to issue spot and you're able to answer the right questions, because sometimes we know just enough to be dangerous. And you want to make sure that you're covering those things that are important in the jurisdictions that you're handling.
Makes sense. So if someone's buying a file in Florida or Georgia and would like you to look at it before they go ahead and purchase it, how long does it take? How much do you charge? All of that.
I always give you the first one free. I try to do that for you guys so that you get to know how I handle things. You get to see the thoroughness of what the job I do. I can teach you along the way so that you can do some of it yourself. Hold on. Frog in my throat all of a sudden. If it's in conjunction with me handling the file, I will also take that into consideration. Generally, I charge $100 a file. If you're sending me files that are 5 hours of due diligence, then I might try to negotiate that a little bit, but I just try to charge $100 right now. I know there are some people that are, charging $300. I don't think that that's proper if they're not doing a jurisdictional specific review. So if you're not seeking a review from an attorney in Florida for a Florida property, you should not be paying somebody $300 to do that.
Yeah, I saw a guy on Facebook complaining that he can't find an attorney in, I think it's Alabama, that will charge him less than $500 to review the file. That's
Yeah.
crazy.
I had a person that I met at the IMN conference this week that was charged $300 by a non-attorney not involved in that state to handle a due diligence review for them.
Wow.
So
Yeah.
for me, they're ways for me to help you guys get your loans. Like, you know, what I look at it as kind of an investment in my, you know, in myself as well, because if I'm doing those things and helping you guys out and teaching you along the way, then I know that that's going to come back to me. So that's kind of why I do it that way. And I would much rather, you know, help you guys out for a little bit of time, whether it be, you know, 30 minutes to an hour, and answer your questions and really look through things and issue spot for you and tell you what the ramifications of that are, than to have you buy something that sucks and then it gets to my office and I have to wipe up the suckage.
Yep. Well, it kind of makes you a partner as opposed to just an order taker.
Yeah.
You know, and that's always better. So, all righty. Well, if nobody else has any questions, we will let you go for the evening. Thank you so much for joining us tonight. That was wonderful.
Thank you guys for allowing me to not put my kids to bed tonight. And if you guys do have any questions, I'll send the slide deck out. Oh, looks like we might have one maybe.
Nope, just a thanks from Karen. You're welcome, Karen.
Okay. If you guys, you know, have any specific questions that you didn't want to ask on the call, feel free to reach out to me. I'll send the slide deck out to Kimberly so she can send it to everybody, and it has my contact information in there. And then once we establish contact, my signature block has my office and my cell phone number, which you guys are free to call. I can't guarantee I'll always answer the phone after hours or on the weekends unless it's an emergency, because I do try to have a life sometimes. But I'll definitely get to you guys as quickly as I can. Oh, and the other thing you asked is how long will it take me to review it? So it only takes me about an hour-ish to review a due diligence, depending on the spaghetti that it is. I do usually ask for just a couple days unless you have a rush request, which I will accommodate as best I can. I am the only attorney in the office right now. I just actually had a second attorney accept a position this afternoon. So I'm working on getting her on board. And once I have that, I'll be a little bit freer and I'll be able to probably get to things a little bit easier for you guys if you have deals that are on the table that need a quick answer. But I'm always willing to try to accommodate that if that's the case. Just don't send me 10 on one day and expect me to get them done by tomorrow.
Gotcha. I think that's fair. I think that's fair.
All right. Well, thank you guys very much. Take care and have a good night.
Good night, everybody. Thanks for joining us.
All right. Bye-bye.